This is Michael Popok, Legal AF After Dark. This past week on Legal AF, the leading podcast, Law, Politics, and Justice, Karen Friedman Agnifilo and me got into it about the Jan 6 D.C. election interference case. What does it mean about the gag order being up on appeal? What is Judge Chutkan going to do next with the jury selection process starting in February? What about all those motions to dismiss the indictment that Donald Trump late filed in the case? Well, tune in now to a clip and we'll give you a taste of what we talked about.
It then goes up to the Court of Appeals on a standard of review that is very favorable to a trial judge. It's the abuse of discretion standard, which means only if the other side shows that she abused a very liberal standard of discretion, quality of discretion, is it going to be overturned. They don't go over all over it again, like all the case law. I mean, they look at the case law, but they really say, did this judge abuse her discretion in imposing the gag order? And under the facts, I'd be shocked if they did. Now, some of the reporting, people got upset because, the appellate court did an administrative stay. Yes, they did, just like Judge Chutkan did an administrative temporary stay of her order. So they temporarily put a pin in the gag until they have time for full briefing. And they set a very aggressive briefing schedule, which will time out for a November 20th hearing. It's right around the corner, just a couple of days before Thanksgiving. And then they'll issue their ruling. In the meantime, if Donald Trump wants to make more evidence to support the gag order, he is free to do so. And the government is free to have the appellate court take judicial notice of all the dumb and stupid things that Donald Trump says. Now, he's been eerily quiet about attacking witnesses and doing all the things. It's as if he's still under the gag order, at least at the moment. It could change, some 4:00 in the morning screed while he's sitting on the toilet where he's known to do his social media posting. It could change all of that. But for right now, he seems to be abiding by it. Then Judge Chutkan, all right, they'll rule one way or the other. They'll thumbs up or thumbs down on the gag order. In the meantime, there's a case. Donald Trump filed 4 separate motions attacking the indictment really late in the game. We're already here, 6 months after the indictment, and they're just getting around. And it's not like they needed to get, I could see if they needed evidence that was in the millions of pages of documents and audio and video that they were given, and they needed that in order to file the motions, but they didn't need any of that because they didn't cite to any evidence that has been provided to them in discovery by the government. So the only excuse for the late filing is they just want to throw sand in the gears of justice and try to avoid the March trial date. They figured that the timing of it, which Jack Smith called out in his papers, he said this is just a weaponized timing of filing motions that they could have filed 6 months ago that they didn't, to try to stop the trial in March. Because that's the Donald Trump's goal here. We know from recent reporting that Donald Trump fears having to be in trial and or convicted, obviously, before the election in November, despite his whistling in the graveyard issues. There's new reporting that a new book by Jonathan Karl of ABC News called Tired of Winning, his third book in the trilogy about Donald Trump, where he yelled and screamed at Todd Blanche when they set the trial date for the Stormy Daniels case to land in March at the time. And he said, "You just cost me the election, you effing idiot." He understands, even though he acts like this is every indictment, every mugshot, every bad ruling against him and gag order is great for him. This is amazing for my, please, more, tired of so much winning. And it's not. And he realizes it in his deepest, darkest moments when he lets the cat out of the bag and the mask slips. And he says, "You just cost me the election." Right. Because these aren't good things to happen to a candidate, despite the base of the MAGA base.
Then he grips off of it.
And he grifts off, right, which is fine. He needs the cash, obviously. But then you have this last 2 developments. I'll turn it over to you, Karen. One is we're going to the jury selection process. The judge wants a questionnaire finished and developed to be used in early February for the selection of the jury. And wants commentary about that. It's not going to be a televised trial, just to make sure everybody understands that under the federal rules and longstanding precedent. And other aspects of jury selection that she wants the jury protected in a certain way. And then just today, actually, as we were going on the air, the judge is calling out Donald Trump on his advice of counsel defense and telling him that if you're going to use it, you got to tell me by the 15th of January who are the lawyers you relied on. And we can make the list. They're all now indicted criminals. Evidence. What evidence do you have that you actually relied on them? And so you can't, the end result of, and I'm doing a hot take on this later today, but the end result of you can't use reliance on advice of counsel to try to defeat criminal intent in a courtroom casually. You're not allowed. You're not allowed to blow the jury's mind and have them question, well, maybe he did listen to a lawyer. There's a rigorous process that's required under the law to use the common law defense of reliance on counsel. And the judge is now setting the ground rules for how that defense is or is not going to be used. Who did you talk to? What were their names? What are the documents or emails, communications that support that you gave them all of the information that was required in order for them to render advice, and that you relied on that advice in committing the crimes that you've been charged with? So that's now just come out. So from a prosecutor and prosecutorial standpoint, walk us through what you're observing about Chutkan, gag order, and now this issue about reliance on advice of counsel.
I think, look, the one thing she's been doing is, it's clear that the defense attorneys want to delay and want a different trial date, right? And they keep asking, every motion is, we need more time, we need more time, we need more time, delay, delay, delay. And she sees right through that. And the one thing I will say is she's very, very conscious of the trial date of March 4th, and she doesn't let it slip. Unlike Judge Cannon, who keeps giving every indication that she's going to let it slip. Judge Chutkan has said this is happening. But what she does do is she gives, if they say they need more time, she set a deadline for filing a motion and they say they need more time, she'll say, okay, I'll give you another couple weeks to do that. But I'm not pushing the ultimate date back. I'll give you a couple more weeks to file this motion, or I'll extend the deadline for something here. And so I think she's making sure that she's being very reasonable. She's listening to the defense, and she's giving them a little bit of leeway when they say they've asked for it. So I think she's definitely being a thoughtful, down the middle judge, and not just only ruling for, she's not a Trump hating, biased, racist judge the way Trump likes to say she is, right? She's being a judge, a really smart judge. There's still some very substantive, outstanding motions that need to be ruled on, right? Trump submitted, I think, 4 different motions. When you add them up, there was like over 120 pages worth of motion practice. And we surmised when he did it that this was they did it that way because there were page limits, right, for each motion, because judges don't like these huge opuses. So they often put page limits on motions to say, this is what the amount of information I think I need to help me make this decision. And rather than having the page limit, abiding by it for all his motions, he broke them up into 4 different motions and made this one long one. And those, they're still outstanding. And, there's been some government response to it, and these motions are going to ultimately, after there's a reply, there will be decisions on them, and they're fairly substantive, and some of them you can appeal, interlocutory appeal, and go up if either side can appeal. So, for example, presidential immunity is a big one that he's arguing. He's saying that his argument is basically, I was the law. I'm above the law. The president is above the law. And since the law allows for immunity in civil cases, it must also apply to criminal cases, even though there is no case law that's ever held that. It's unclear one way or another, but it just defies common sense, right? That Trump, that a president, any Trump, could bribe officials or could sell nuclear secrets to a foreign government or could, whatever. Like, there's so many things they could do while president that it makes no sense that they couldn't be prosecuted for, right? Even if it's technically, he'll say, oh, it's within the bounds of what my job was, right? I'm supposed to deal with foreign governments, but you're not allowed to, illegally sell nuclear secrets kind of thing. So, it doesn't make any sense that would be this, ultimate kind of, you can do whatever you want and not have any consequence. But, what they're going to make this argument, and, the judge is going to have to rule on it and find, even if there is some form of presidential immunity for some criminal activity, the judge will have to make a finding that this conduct falls outside of what's allowed. So that's still something that needs to be resolved and could be appealed. And, let's say the Supreme Court would want to rule on any of these motions that are still outstanding. I still worry a little bit that the trial date could be slightly slippery as a result. The other motion, one of the other motions had to do with constitutional grounds. And I think this is why he hired Chris Kice, who was a former Solicitor General of Florida. And for non-lawyers out there, a Solicitor General is like the government. It's the government version of the really smart lawyer who argues to the highest court of appeals, right? Whether it's the Supreme Court or in the state. And they're the ones who bring these arguments on behalf of the government at this high appellate level. So if you're a Solicitor General, you're a constitutional lawyer, you're a decent lawyer, and Chris Kice, has that reputation. And I think these 4 motions that were submitted, I think, were really what he was hired to do. But so this next one, the one on constitutional grounds, there's a couple of, he wrapped up a bunch of arguments into this one. One was, he had a First Amendment right to give voice to the millions of people who thought he won the election. Number 2, that double jeopardy applies because he was acquitted in the Senate for the same charges. And so therefore you can only you can only prosecute him once. And he also says that since the Constitution says the remedy for a president is to impeach and then convict and impeach, and then it says in the Constitution, and then he can be indicted if he's convicted on the impeachment, that bars any ability to prosecute him if he's not convicted but again, it's like he's reading something into the law that's not necessarily there, and it's unclear, but who knows what the Supreme Court would do. And then the third constitutional argument he made was a due process violation, saying, he didn't have notice that, he basically said that the law's vague. The third motion that they filed was on statutory grounds. They basically said they don't like the way the indictment reads. They said it doesn't give enough specific information, but that one's going to fail for sure because indictments are supposed to be bare bones on their face. So I don't have any worry about that one at all. And I also am not worried at all about the fourth motion that they submitted, the selective and vindictive prosecution. Those rarely succeed, and that argument there is where Trump said, they went after me in a vindictive way selectively, and it's not, and that doesn't work usually because, you have to show that the prosecution, that the decision to charge him had a discriminatory purpose. And I think he's going to fail on the law and on any facts there. So those are still very substantive motions that are out there that Judge Chutkan, I think, will make a great record on those. But it's the interim appellate piece of it that I'm a little bit worried about. What about you, Popok, on those?
The thing I like best about Jack Smith's caught me at a snack. We start again. Sometimes I snack on my co-anchors. It stays in the pot. I liked about Jack Smith and his responses. He's solving the riddle that Donald Trump keeps putting out there, that since I believed in good faith that I won the election, everything I did is completely absolved, all my criminality. No. Jack Smith actually said in his recent filings, even if Donald Trump reasonably believed, and he can provide evidence to show that he had a reasonable belief at any given moment that he had actually won the election and not lost it, the specific lies that he used at any given time, which are all listed in the Jack Smith opposition papers: dead Georgia voters, dead Nevada voters, dead Colorado voters, software flipping votes from Trump to Biden, all lies. Oh, okay. We got breaking news we're going to break into here. I'll come back to my point, but I think this is important. There's been a trial in Minnesota, and it went up to the Minnesota Supreme Court. At the same time, the Colorado was trying the case of whether the 14th Amendment, Article 3, banned Donald Trump from the ballot. Colorado, Minnesota, Michigan. They're all considering these cases in different ways. And while things are looking good for banning Donald Trump in Colorado, on the weekend edition, Ben and I speculated based on the oral argument there. We'll be talking about oral arguments later in the Supreme Court. Based on oral arguments and statements made by even the Chief Justice of Minnesota, that it was unlikely that they were going to bar Donald Trump in Minnesota, instead finding that it was a political question and that it was something for Congress to take up. Exactly the opposite of what the Denver, Colorado trial judge has already ruled. She said it's exactly the type of thing that judges have to consider, which is the interpretation of the Constitution. And I don't need help from Congress in order to do that. But Minnesota has just come out, as we're on the air, with a ruling that is going to permit Donald Trump to be on the state's Republican presidential primary ballot. They said that a new petition could be filed challenging his eligibility for the general election ballot. But, based on their denying the petition without prejudice for the general election, you've got and signed by that Chief Judge Hudson that I said out loud during the oral arguments. And why, if we could do this, should we do this? This seems like a political question for Congress. Ben and I were like, there's no way that we're going to win in Minnesota on this issue. And there's the proof of the pudding is in the tasting. We've got the new ruling that's just come out. Karen, you want to comment on that before I double back on Jack Smith and we complete this segment?
Yeah, look, these are ones to watch, all of these. I'd be very surprised if he's kept off the ballot. I mean, of course he shouldn't be on the ballot because for the obvious reasons that, the 14th Amendment disqualifies him. But I hate that it would then allow him to say, to say the election was stolen from him if he's not on the ballot. I want him to be on every ballot and I want him to lose fair and square. And, he'll still claim it was stolen, somehow. But I do have very mixed feelings about these.
We'll continue to follow it. And, Colorado's got one that's I think we're going to get a ruling from that judge any day now. Minnesota, no surprise. Nobody should be shocked by this one. And my last point on Jack Smith was he, having outlined all the fake lies that Donald Trump relied upon to pressure election officials, elected officials, Mike Pence, dead Georgia voters, dead Colorado voters, software that was fraudulently flipping votes. None of that was true. All of that was debunked. None of that could a reasonable person have relied upon. They said in their filing, even at some point, if he had a reasonable belief that he won the election and we don't see it, the use of these specific lies in and of themselves is the conspiracy, is the crime. And so you don't get a pass, because at some point in the continuum, you may or may not have been right. You were wrong about these things and you knew or should have known that they were fake and false, and you used them anyway. So that's what we got going on with Judge Chutkan, who, I agree with you, there could be some slippage, Karen, on the date. We got two backup trials ready to step in. We've got one that's still on the books for the 24th of March with Judge Merchan in the Stormy Daniels hush money cover-up affair and the books and records fraud as it results. And we got Judge McAfee and Fani Willis waiting, I think, champing at the bit to file to get their Trump Georgia election interference and conspiracy RICO case up on the map. So if it slips, I think there's two backups that'll quickly slide into that spot, one already being on the books.
Well, there's an example of what we do every week exclusively on the MeidasTouch network. It's a podcast we call Legal AF. It is what you think. On Wednesdays, it's Karen Friedman Agnifilo and Michael Popok. And on Saturdays, I'm joined by Ben Meisalis, co-founder of the MeidasTouch network and a civil rights lawyer as well. And we do 4 or 5 of those stories at the intersection of law, politics, and justice, just like you saw in that clip. If you know about us already, welcome back. If you don't know a thing about Legal AF, you just had an example, a little bit of a teaser of what that show and that content is all about. And if you know people that are interested in the show, but you never wanted to send them the entire hour show, send them that clip. It'll give them an example of what we do on a weekly basis. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.